watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. The Florida Supreme Court is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is Knight versus the state of Florida.
Good morning, may it please the court. My name is Melody Smith. This morning I'd like to present arguments on three issues, issues 1 and 4 in tandem, and then issue number 3. In the guilt-innocence phase of brain-damaged Richard Knight's trial, Hans Mulling, Odysseus Stevens' partner and Hanesia Mulling's father, was on the phone when he heard news that something happened at his house. In response, to the state's question, when he was testifying before the jury, they asked, "Why did you rush back?" He responded, "I assumed Knight and Odysseus probably got into an argument or something because I know Richard's violent background."
Now, what happened when that was said?
Knight objected, his lawyers objected, they moved for a mistrial. The court held a hearing, I believe it was...
The court sustained the objection, is that correct?
Yes, Judge. Yes, Justice, Chief Justice. The court sustained the objection. And then there was a hearing, I believe it was in 2 parts, that day and then the next morning.
Didn't the judge also instruct the jury?
Yes,
Okay.
Justice. The trial judge did hold a hearing, and following an argument by the defense and the state, the judge made a decision to deny the motion for a mistrial and instruct the jury. It's called a curative instruction, but that remains to be argued at this venue. Instructed the jury to disregard the statement. So everybody conceded, as it's clear, that it was an inadmissible statement. And what happens is, instead of a bell going off, as Dunn discusses, a bell goes off. My mother collects bells. They're loud, they're clangy, they're soothing, they're soft, they're annoying. But this was an alarm. This was not a bell. This was an alarm that was alarming, was startling, was frightening. And it was confusing then for the judge to say, I'm sure to the jury, that this was to be disregarded.
Did the defense attorney offer any other instruction that he wanted the judge to give?
Defense didn't believe any instruction would be curative, Justice.
And so, I guess my interest is what was said about the violent background from there. Was it argued by the prosecutor that this man had a violent background? What use was made of that statement?
Okay. The statement, let's take the statement first by reminding ourselves who said it. This is the murdered victim's family member who's on the stand in the guilt phase describing what he knows.
Right.
So when he says this, right.
That's what I'm really interested in, is from that point. This is a statement, couple of words basically. What use was made of it?
Okay. Well, again, we know who said it, and now it was in response to. I'm going to get to your question, I promise you, but let me just describe. This was a question that was asked by a prosecutor. Nobody gets out of law school and knows, especially seasoned prosecutors, and ask a question they don't know the answer to.
Well, wait a minute. The prosecutor didn't ask him about a violent background, did he?
Well, that's the point. He asked him, what was basically, why the rush? Why'd you go back? Remember, Mr. Mullins didn't say, I was sad, I was scared, I was frightened, I was worried about everybody. What he says is, I assume they had an argument because I know Richard Knight has a violent background.
But your suggestion that question was calculated to get that particular response seems to me to be very speculative.
Well, Justice Kennedy, again, every lawyer practicing law knows you don't ask a question in that venue in this series of a case.
Well, I know that's good advice for lawyers to follow, but I also know that a lot of things happen in trials and nobody anticipates, and witnesses say things all the time that cannot be reasonably anticipated. That's just the dynamic nature of a trial process.
Right, and I just argue that it's difficult to believe that this Mr. Mullins has not previously made this statement to these prosecutors before.
Did he make any reference to anything specifically as relative to the violent background?
No, he didn't have to. It's not a general comment about his criminal history or he's a convicted felon. This is a word that invokes fear and angst, and again, it's an alarming statement. And want to distinguish
at what point in the trial did this take place? Was this in the earlier stages, or?
This was within, after jury selection, probably within the week. I think it's the first week of trial. It wasn't a long trial.
So the jury had heard the violence about what happened during the trial?
The case was a very violent case. 2 people were stabbed.
Well, let's go back.
Yeah, sure.
I'd like to just test out further your assertion that the prosecutor knew and evoked this answer, because I certainly would agree that if there is something where a prosecutor knowingly elicits something that is clearly inadmissible, that what you look at is somewhat different. But other than saying that people always know what their witnesses are going to say, was Mullins deposed before trial?
He was deposed. He was given his statement. He was given his deposition.
And did he say that in the deposition?
I don't know whether he said it in his deposition. I'm sorry, I don't know the answer. I haven't reviewed the deposition lately.
All right,
but I do know that prosecutors
but you're
know
making
these things.
a very. What I would suggest you do is, we're going to have to assume, because this record doesn't show to the contrary, that the prosecutor did not intend to elicit this. What was the question specifically that was asked of Mullins?
Specifically, the question was, why did you rush back?
Now, do you think, was there anything about that question, about why did you rush back, that you think was an impermissible question?
I think it's a question that you ask in a very clever way to elicit a response. It wasn't, how did you feel when you heard what happened?
Now, why did you rush back? Now, the fact is, the first part was,
he'd heard that
truthfully, I thought they had a fight. Now, the background is that this defendant was in the house and was told he really was going to need to leave the house. And that was something that he knew that his girlfriend was unhappy with. So the fact of saying, I assume they had a fight, is not in itself something, because that's what in fact happened. I mean, they had a fight.
I agree.
Okay, so the only part, and I guess I want to talk about how this then rises to the level of a mistrial, because I do agree that there are some things that you can't unring the bell or the alarm. But as Justice Perry was saying, he doesn't deny being at this. He's the only one that could have committed this crime. Is your defense that he wasn't there?
Well, the defense was that he wasn't there, and there was additional DNA that didn't belong to him. There were no fingerprints on the knife.
Their blood was all over his clothing.
Their blood was on his clothing.
And it was a violent crime.
And it was a very violent crime.
Do you really think that the jury, in deciding whether they're going to convict this person, is going to say, well, I don't know about, whether he was there or not, or whether, but boy, somebody said something about him having a violent background, so he must be guilty. And in this case, I think that's what the judge was weighing, is looking at whether, in light of the facts of this case, whether this single statement so infected the trial that Mr. Knight could not get a fair trial. Is that the standard?
Justice Perianti,
is that the standard?
This is a death penalty case.
Is that the standard, that the judge makes a decision looking at it as to whether this single statement so infected the fairness of the trial that Mr. Knight could not get a fair trial? Is that the standard?
It's the standard. I'm not sure the judge used that standard. Judges don't, everybody who goes to trial, judges don't like to grant mistrials. They don't. And if there's a basis not to.
But again, this is just entirely speculative. It is not, you don't think the judge used the standard? I don't understand what basis you have for making these assertions you're making.
Okay. Let's move to point 4, which is in tandem with 1.
You danced around answering a question as to whether this was used at some other point in the trial, how it was used, that was pending. It's been pending question for about 20 minutes.
Yeah, thank you.
Could you please?
Justice Quince, Justice Lewis, thank you. So, because violence was a pervasive term in this trial, both in arguments but also in the nature of the case, of course it was used over and over again. And the word is not. The word has impact. Of course, it was used over and over again. How? The impact of the word violence.
But weren't these people stabbed 26 total times? Doesn't that connote? What does that connote? What other word was used other than violence?
That's the point, Justice Perry. It's a violent crime.
Was there a connection of this violent propensity? I think is really what she's getting to, because it's understood this is a very violent, or appears to be a violent situation, and I think that's where the question was going. Was it argued that this defendant had this, and was that played upon the statement, the violent propensities, violent personality? Was that, or was it just the word violence because of the scene?
It was a violent background, was the assertion, and the violent crime.
I guess I think what the justice is trying to ascertain is whether or not this was isolated or was this played up over and over and over again.
Well, again, the state argues it was unsolicited
about the violent background.
Isolated.
Now, there was violence, obviously. The violent
Our
background.
Our position is that it wasn't isolated, Justice Perry, because
you said it wasn't.
It wasn't.
Tell us.
It was part of the trial. Right.
Tell us specifically where the prosecutor said anything more about the defendant having a violent background. We all know this case was violent. We are talking about whether the prosecutor played on of whether or not he had a violent background.
Prosecutor didn't have to, Judge Quince. Damage is done.
I'm asking you if he did, not whether he had to. Did he ever take that statement about the defendant having a violent background and play it up for the jury?
My argument is that the continual worse of the
word. Is the answer no or yes?
Yes.
And where would that be?
Continually throughout the trial when it was referred to as violent. Okay, that's my argument. I'm sorry. If we address issue 4,
did they ever refer to the background after that?
didn't.
No. So the
Not
answer to
in the
that's
guilt
no.
phase. In the innocence phases, which is issue 4, that it's in tandem now. What I want to talk about, if it's okay.
Well,
of
obviously,
course.
in the penalty phase, it's a different
Yes, sir.
story.
And in the penalty phase, again, didn't have to do it. In fact, it's still pretty much inadmissible as non-statutory aggravation. Just to talk about.
I'm just concerned that a specific question is asked, and it was asked in a way that it's either a yes or a no. Did the prosecutor take it further and then extol the fact that this man had a violent background?
The answer to that question is no.
Okay. Thank you.
The defense at the beginning, before the penalty phase began, requested a new jury panel, and that motion was denied. And the argument defense counsel gave the judge was that because the statement about his the assertion that he had a violent background was made in the guilt phase, that this jury panel was essentially already tainted. They convicted him.
Was there any testimony in this trial about previous arguments between the defendant and the victim, or the defendant and the husband, father of these victims?
No, Justice Quince.
Okay.
In fact, the mitigation presented during the penalty phase doesn't illustrate that that Mr. Knight had that type of violent background. It just doesn't, it's not there. And so the comment that was made, the assertion that was made, is highly prejudicial when it's presented in the guilt phase, and it has this, what I thought of as it permeated the entire atmosphere, colored the whole.
Now here is, let me go back to this. This is the
Yes, ma'am.
victim's boyfriend, and it's the father of one of the victims who's now testifying. Obviously, he's got an interest in this. I could see your point if it was a police officer who ended up saying, in response to the question, why did you think you would arrest Mr. Knight? Because we knew of his violent background. Well, now you got a different thing. You got an officer of the law sort of saying something, and then you go, I wonder what his violent background is. What's going on? But this is just this is a distraught person, and then in the penalty phase, they bring out all these things at Mr. Knight, that he had a good background, went to high school, excelled in art, admired by the children. The state doesn't try to bring out that to impeach him with something else about, well, didn't he have a violent background? So I don't even, it starts to become less and less significant, it seems to me, in the penalty phase.
He's on death row. He got two death sentences.
He killed 2 people.
Right. And 98 out of 100
and a 4-year-old is one of them.
Don't get put on death row.
Excuse
Especially
me?
98% or 98 out of 100 people don't get put on death row who killed him. You know that.
Well, do you think in this, now you will talk about if you're going to proportionality, this is somebody who killed 2 people with HAC, with one being 4 years old. This is among the most aggravated and least mitigated of cases. Just without that, can you make a different argument that this, in another situation, wouldn't be a death penalty case?
Justice Perrin, I have seen cases that pled out where they pursued the death penalty and the person didn't get death row. Yeah, death as a sentence. But that's not what you're looking for. And I'm not prepared to argue in the dozens and dozens of cases that this case is not distinctly not proportional. What I do want to suggest is that the state didn't have anything to come back with to argue violent background. But they didn't have to. It was, of course, the crime itself was terrible. You know, it was violent.
Did he have so there's no evidence that he had a violent background?
No, Justice.
No prior violent felonies?
No. Well, what about the violence to his girlfriend? Didn't he resist arrest with violence? I mean, did he not? Did I read the wrong case?
Well, you may have read charge, but usually those cases are associated with, forgive me, but with when people get beat up by police officers, the charge is usually resisting with violence. I'm here to argue for my clients. I'm here to argue for my client who's facing the death penalty.
The reason we're looking at you, Ms. Smith, is because you seem to be arguing about things that might happen in the general world, and that's not what you're here to do. You're here to argue the facts of this case and make a legal argument, not talk about whether this is, in your experience, and I'm not sure what it is, that you find this happens or that happens. That doesn't help this court in making a decision.
The assertion about Knight's purported violent background was not disregarded. It's our argument. Penalty phase was irrevocably, variably tainted. And I don't believe that it's our argument that the jurors could not disregard Mulling's assertion, permeated the entire environment, and that Mr. Knight was denied a fair penalty phase.
Ms. Smith, I just wanted to let you know you're now into you wanted to reserve 15 minutes for rebuttal, so you're down to a total of about 11 minutes. So
yes, Judge.
You're certainly welcome to proceed now. But
no, Justice, I'm going to state just on point 3, and then I'll continue with the rebuttal following the state's argument. That on issue 3, I wanted to argue from a legal perspective that this DA evidence testimony that changed from before trial to trial hindered the defense trials.
Would you explain that? I know you're in your rebuttal, but would you explain that a little bit? Because actually I find that a more compelling, more interesting argument than the other one, which is you're saying that before trial, the state gave the defense this expert's testimony, and that later the expert did some additional testing, which changed his opinion.
Yes, Justice Quince. While they were in trial, jury selection had already started. Evidently, the expert changed his opinion, and you maintain that was based on additional testing. Do we know that as a fact, or is that speculation? What was the testimony, Justice Quince? It was the testimony.
What was the testimony?
There was additional testing, and it was requested by the state, and it was done after the trial started, and then when the first time, if you can imagine, the first time, and again, I do have some experiences. That's why I look at it from that perspective. You hear this is when the witness is testifying, and you're, as a defense attorney, you're flat-footed. You're being blindsided. Your defense strategy has changed, and the commotion that ensues is
because again, let me make sure I understand what you're arguing here. You are saying that the prior information that was given to the defense said your client's DNA was not on a certain piece of evidence.
It was excluded from the boxer shorts, yes.
But then at the trial, the expert testified that your client's DNA was on that same piece of evidence.
Actually, Justice Quince, what he said was the expert said that after doing a different calculation with somebody else in the mix, it could not be excluded. He didn't say it was in this.
Okay. He could not be excluded, whereas before he definitely said it was not his DNA.
Excluded.
Did it go in any way to the blood that was found on this defendant?
I'm sorry, Justice Lewis.
Did it in any way address DNA findings with regard to the other blood that was found on the defendant that belonged to the victims?
Did defense counsel?
No. Did this new, whatever happened later, did it in any way address those findings?
Justice Lewis, the changed opinion did not address the other
blood.
Right.
Okay.
May it please the Court, Lisa Marie Lerner with the Attorney General's Office for the State. Addressing issue 3 about the DNA evidence, I have to respectfully disagree with my colleague. What happened was the State did not ask any expert to do any additional testing. no additional testing was done. The person who was testifying was Mr. McElfresh, I believe his name was. He had never done any bench work or testing in this case at all, nor had he ever written a report that was given over to the defense. The person who had done the actual testing for Bodie Laboratories and had written the report was Faith Patterson.
Well, was Mr. McElfresh given as a witness? He was on the witness list?
He was indeed on witness list.
And was there any indication given to the defense about what he was going to say?
No, nor did the defense ever depose him. The defense was also given all of the information in this case, the handwritten bench notes from the Broward Sheriff's Crime Lab who did DNA analysis, all of the results from Broward.
So he was making this assertion based on other people's work?
Yes. What had happened was that the Broward County Crime Lab, Mr. Knoppinger, I believe his name is, and the expert from Florida International University had created a chart with the standards of Knight, Stevens, Mullings, and then Martino, as I believe.
And who was she?
She was Knight's girlfriend.
Victoria Martino?
Yes.
Okay.
And so Broward had this exhibit with the 4 standards that they used in their testimony about the results that they got. And the state attorney looked at that and noticed that Bodie had a different exhibit and had only 3 standards on it instead of 4. But I wanted to go specifically to the DNA in question. The clothes in the bathroom were a pair of boxer shorts, a pair of jean shorts, and a plaid shirt that were rolled together in a ball. So they were not separated in different piles. They were rolled together in a ball and put under the sink. On the boxer shorts, which there was testimony they were Mr. Knight's, they were the same type and size that he was wearing when he was arrested as well. On those boxer shorts, there were stains all over the front and back from Stevens and Mullings, the mother and daughter. There was a spot on the back of the boxer shorts with a mixture of Stevens and Richard Knight. There were 2 stains on the boxer shorts, a single source stain, and the experts testified that it's 100% certain in a single source stain that it was Richard Knight on those boxer shorts. So what happened was the crime scene analyst doing the DNA work took swabbings from the waistband area. This was not blood evidence. This is just swabbings like you'd take a cotton swab and swab for skin cells. And they sent those out to Bodie Laboratories from the boxer shorts. One of those ownership sites, is what they're called, came back as including Richard Knight in it. The other of those ownership sites, initially Faith Patterson excluded Richard Knight. It was that second spot that was the source of this contention that there was a discovery violation. But Richard Knight was inexorably linked to those boxer shorts by his blood, Stevens' blood, and Mullings' blood, putting him in the position of getting their blood on his shorts, and he bled too. He had cuts on his hand from the knives, which was the source of his blood. On the jean shorts had blood stains all over them from Stevens and Mullings. The plaid shirt that was...
something that's very interesting. You say his hands were cut and his blood was on these items, yet there were no fingerprints or anything on the knife itself?
That's correct. However, there was a testimony by Mr. Whitsitt, unfortunately a jailhouse snitch, who testified that Knight told him that he wiped down the knives.
Could you address, You've gone all around to show the other links. So how would you describe whatever occurred with regard to the change? It was only the waistband, is that what you're saying?
Yes, it was the waistband.
And how did that come about?
It came about because the state attorney noticed when, during the trial, noticed that Bodie Laboratories didn't have the fourth standard on its exhibit. And he sat there and personally compared it and said, well, this matches Victoria's. And he apparently talked to the expert and said, will you look at this and see what you think of it? The expert did. The expert testified. I also want to point out that the state was not trying to hide anything. The state presented Faith Patterson, and she testified that she excluded Richard Knight from these two spots, one on the jeans and one on the boxers. This Mr. McElfresh also testified initially that it looked, based on the information Bodie had, he would have excluded her too, but based on this additional information he was given at trial, he now included him.
Now, that additional information that was given to him at trial, did the defense have access to that information?
The defense had that for at least a year before trial. It was the standard from Victoria Martino, and it was also the standard that was used during the testimony from the Broward DNA experts. The defense had all of that. Both parties, the defense included, agreed that the defense had that information. The defense gave that information to its expert who had it and could have looked at it just as the state attorney did before trial. Additionally, the court found there was no discovery violation because they had given everything over. However, the court did something very interesting. Even though there was no discovery violation and it was not material in the information because the defense had all the information, the court went a step further and actually decided to fashion a remedy anyway so as to not prejudice the defense. The court gave a recess in the middle of the guilt phase trial for 12 days to allow the defense to get this information and the transcripts to its expert and have its expert come into court to testify if the defense wanted to do that. The defense took the 12 days, came back, said that he had given all the information to his expert and had made a strategic decision not to put his expert on and not to challenge the state's DNA evidence. So
even if that particular item was challenged, it just seems to me that we have his DNA on other things, don't we?
Overwhelming. Ms. Stevens' DNA was found on the shirt he was wearing when he was arrested and on the boxers he was wearing when he was arrested. Knight had blood on his hands when he was arrested, and the police very properly and quickly took swabbings of that blood. The blood on his hand was a mixture of his blood and Ms. Stevens' blood. Ms. Stevens also, Knight had scratches on his chest and a bruise on his shoulder. There was evidence that Ms. Stevens had Mr. Knight's skin under her nails. His DNA showed up under her nails. The two victims are linked to the clothes in the bathroom, the clothes he was wearing, the blood on his hand, and his DNA was found under her nails, and he had scratches on his chest.
Well, plus in terms of that aspect of the evidence, I mean, there was no break-in in the house.
Correct.
I mean, the doors were locked.
Correct.
I mean, was there ever a suggestion of there being other suspects?
No, Your Honor. And also, interestingly enough, the woman upstairs called 911 at, I believe, 12:21. The police got there by 12:28. The police knocked on the door and then started walking around the apartment. The police noticed that the lights were on in the master bedroom and in the apartment and that the windows were closed. He went back to the door to try and see who else was responding from the police department. He then walked back around the apartment, noticed that the lights were now off, the window was open, and the blinds were out of the window. When Knight was stopped by the woman police officer over by the bushes, he was wet, hair was wet, his clothes were wet, he had a dirt mark on his back, which was consistent with leaning against the windowsill to get out. There were 2 wet towels in his bedroom, and the shower in his bathroom had been used.
Just as far as the time frame, I know that they excluded the boyfriend as a possible source, a defendant. He had gone to Kinko's, but that was like at 9 o'clock?
No, he was, there's a videotape and also the cash register receipt from Kinko's showing he was there between 11:45 and 12:15.
Oh, okay. For some reason, I thought I had seen 9 o'clock.
Well, he left his office 9 o'clock.
Right.
And he went to Kinko's and dropped some relatives off, his brother off, and somebody else off, went by his mother's house.
And then he got a call. So when he got a call from the police. I guess we might as well go into this first.
Well, no, he
You want to go into the first issue that we spent a lot of time on? He was called by who?
He wasn't called by anyone. He had finished his business at Kinko's. He was making flyers. He was an event promoter. That was how he worked. He finished making the flyers, and he went back to the apartment, and he saw some police officers there, and he stopped and went over to the public shopping center across the street to call his house, because he recognized the police officers, because the same police officers had been out a week or two before because Knight had been involved in a traffic incident. He actually recognized the individuals. When no one answered from his home, he then called a friend to try and do a 3-way to his house to see what was going on. It was while he was on the phone with his friend, he had no idea of what had happened over there, that he noticed what he initially thought were hoses from or something he saw was crime scene tape. And then he noticed that there were a lot of officers over there, so he quickly got off the phone and went over to the apartment complex. And that's the substance of where this statement came up.
So, okay, the substance being, what was he thought to himself? Did he say to somebody, I mean, this is what he thought, that, it must be, he must have gotten in a fight because he has and I know he has a violent character. In other words, how would that even, you agree, and I mean, I think the state agrees, it's not relevant. I don't even know, why was the question even asked?
Well, because it looked odd, and in my brief, and in the transcript, it's 5:25:27:09. He was trying to explain why he didn't just go straight home and why he was over at Publix making these phone calls instead of going straight home. And the prosecutor was asking him, so why did you hang up and go at this point? And in fact,
so what would the prosecutor have thought was going to be the answer to that? Like, why did you go? There was no indication that he had ever said anything that I went because I thought there was a fight.
No.
But what was that asked in a deposition?
Nothing was brought up by this. I mean, no one asked Mr. Mullings, did Knight have a reputation for violence, and it never came up pre-trial.
But why? I think Ms. Smith's argument is, since we all do agree that people, prosecutors, defense learn as a fundamental principle, you don't ask a question that you don't know the answer to. When he said, why did you do that, what was the answer he thought he was going to elicit?
Well, was that he was going to go over there because he saw the police officers and wanted to contact his family. That's what he had said before.
Well, now, his response was on redirect.
Yes.
So he had been crossed.
Exactly, about why he was delaying, because the defense was trying to paint him as a suspect. Okay. And he was trying to explain how he wasn't a suspect. And in fact, he did not say that he thought Ms. Stevens and Knight had a fight. He said he thought they had an argument. He actually used the word argument, and then said, because of Richard's violent background. And the court did a hearing on this, talked to Mr. Mullings and said, what are you talking about? Because the state didn't know what he's talking about, neither did the defense. He testified about some incidents when Knight was a teenager. The court specifically directed him, absolutely do not say anything about this, really read him the Riot Act, and then, gave a curative before they had this hearing, went back, and the court made findings that this was an isolated comment. It was nebulous. It didn't have anything to do with a specific act or problems with Ms. Stevens or anything.
He said a violent character. What did he say?
Violent background.
Background. So you can, I think we all agree that it's not only impermissible, but under other circumstances, it could have infected the trial, depending on then what happened. Your answer is, did the prosecutor ever talk about the violent background or anything about it again in the rest of the trial?
No. It was never raised again. It was not used in closing argument. The prosecutor had specific acts of violence that he could have used from Jamaica, did not use it. In fact, the state did not put on any case in the penalty phase, did not challenge Knight's character at all. All the witnesses at the penalty phase were people saying what a nice guy Mr. Knight was.
But Ms. Smith's argument is, once the jury hears that there's a violent background, you really don't need to say anything more. But they just know it. I just want you to, that's her argument. What's your response to that?
A violent background, as a trial court indicated, could mean violence against him, argumentative family life, anything. It was very nebulous. It was not saying that he personally was violent or he had behaved violently in any way, because the comment was violent background.
And he did say, as you said, they thought they had an argument. He didn't say, and I thought, he must have killed my girlfriend. I mean,
No.
There wasn't anything like that.
No, he used the word argument. And so, given the context of both the comment and the overall trial, the trial court denied the motion for mistrial, and I don't believe it was an abuse of discretion. I also want to point out that this comment was made, I believe, on April 5th. The jury did not even get to closing arguments until 18 days later.
But I guess, again, the point about these types of things, and depending on what they are, is that sometimes once something is said, you remember that. I think that, and there can be, it's when we talk about not being able to unring the bell, determination is whether in this case that's one of those types of things that once the jury hears that, they cannot give this defendant a fair trial. I think that there's all the reasons why this isolated comment would not meet that standard, but there are those, the fact that a few weeks go by isn't necessarily the test, but you're still saying it's isolated, never brought up again, and not brought up in the penalty phase in any way either.
Correct. And there's no way, given the other evidence brought out at the trial about the stabbing of a 4-year-old child and whatnot, that this could vitiate the fairness of the trial.
You talked about the time of the trial. This is a murder that occurred in 2000?
2000.
And the case style from the lower court is 01.
Yes.
The case, a sentencing order doesn't occur until 2007.
Yes, and the trial was in 2006.
Is there an explanation in the record for the reason for this type of delay to bring this defendant to trial? Just in the record, not...
Yes. There's evidence from the chief investigating officer that the reason he waited a year to get the indictment was that he had to interview all the witnesses and he wanted to make sure all the DNA results were back.
No, I'm asking for between when it was filed and 6 years trial or 5 years.
Just looking at the motions defense preparation.
And then this case was filed here in 2007. Now it's 4 years later. Do we know have the reason in the record for the inordinate delay in getting this case here to oral argument?
Yes. A number of defense attorneys, firms, alternate public defenders and whatnot, were assigned to this case, and each office kept it for about a year, supplementing the record, and then had to get off of it either for a conflict from the public defenders, and then I believe the alternate public defender office said that they didn't have the manpower to finish the case after they had had it a year. And then Ms. Smith got it and did it expeditiously. But finishing on point 3, as I said, there was no discovery violation found. I don't believe that this court's going to be able to find an abuse of discretion on that. But even though there was no violation, the information was not material.
But you're saying if it was a violation, it was remedied by what you just said. It was a 12-day recess to look into this.
Right. This judge was very careful. And we asked the court to affirm both the guilt verdicts and the death sentence.
Thank you again. I would like to ask you to refer to the record on this, going to address issue 3. What we're purporting is, and the state has agreed, was a discovery violation. Was the
remedy? I don't think they agreed it was a discovery. I didn't hear Ms. Lerner say she agreed it was a discovery violation. I thought she's giving it. Let's just make. I thought you said alternatively, even if it were, but I didn't hear the concession on that.
Volume 32, the trial, pages 3459, 3460. The trial court says, "I don't believe the violation was inadvertent." So at least the court believed it was a discovery violation. It offered a remedy that wasn't sufficient for defense trial to do what they felt like they needed to do.
What would have been, what did the defense need to do, further need to do? A 12-day recess wasn't enough?
This is, the presentation of facts is always trickier, but the remedy, I'm not sure what the trial transcript said about the remedy was that their trial strategy had been so damaged because they had been going along the line of innocence, trying to say that because there were no fingerprints on the knife, there was another person's DNA, a female person's DNA on a shower curtain, that the now admitted testimony that Mr. Knight's DNA was not excluded from the boxer shorts and another item, I believe, the jeans.
Yeah, explain whether this is what I understood Ms. Lerner to clarify is that this affected only the area in the boxer shorts at the waistband, and that there was all this other, that the blood of the victims, first of all, they were his boxer shorts, he lived there, and that his blood and their blood were all still on the boxer shorts. Is that incorrect?
I don't believe that's incorrect.
That's correct.
I believe that's correct, but what the defense...
So how does, the defense knows that going in, how is that
right, and the defense argues that it has not called an expert to dispute that. Then it hears that the other items, the DNA was not excluded, and it basically wipes out their strategy that this is a person who has been excluded or has been included. So the report that they got, and again, if I could just refer you to the record, a couple of sites, it might help in my rebuttal argument. In volume 31.
Excuse me. You just extrapolated one line from a judge's monologue.
I did.
Said, all right, I don't believe the court finds the violation was inadvertent. But above that, he said that it doesn't create a discovery violation. And after that, he said, in view of the fact that Mr. Knight's DNA was found previously reported prior trial, I don't find there was there was substantial, that is, substantial. And even if it was a violation, it wouldn't be substantial because the state had already evidence. I mean, he clearly kept saying, it seems as if the statement was taken out of context.
Well, I don't think so, Justice Perry. He says, I don't believe the violation was inadvertent. He did say that he thought it wasn't a violation. I mean, the judge was all over the place, I agree. But at one point, he did say that it was a violation that he said, I don't believe the violation was inadvertent. That word inadvertent refers to a violation. There is no violation.
But all around that, he says it was not a violation. Up, down, before it, and in between.
That's right.
Okay.
He says both, but our position is, and the facts remain, that he said it was a violation that was inadvertent, amid all of his other comments and his potential remedy. Justice Periente, when the defense had its time to effectively try and now either rebut or defend against the statement, from what the transcript says, and the defense attorney tells the trial court, is that their trial strategy was damaged beyond repair, that they could not bring somebody in at this point to testify to something that would be consistent with their trial strategy.
See, I understand that, and I can see there are cases where something is not revealed, that they've now made a statement. I was still just trying to understand. I'm not sure you've been able to convince me of it, that with all the other DNA, to have a defense that he wasn't there seems that I don't see how this particularly changes that. And so can you make one more try at explaining how?
I'm not sure I could. Thank you, Justice Periente. I'm not sure I could argue that he wasn't there, but I could argue that he might not have been the killer.
But can you tell me with the blood, what was the explanation going to be about the blood that they could no longer make because of this other testing of the waistband?
That he could not be excluded, just to add to the other comments and the other testimony and evidence. Okay, any other questions? Thank you very much.
We thank you both. The court will now take a 10-minute recess.
Please rise. Court is in recess for 10 minutes. Please rise. Florida Supreme Court is again in session. Please be seated.
The next case on our docket is Bizia versus the state of Florida.
Morning, may it please the court. I am Maria Liberado, and I, along with co-counsel Mari Louise Samuels Farmer, represent John Boozia. I'm going to focus this morning on issue 1, where despite presenting a number of witnesses, counsel rendered ineffective assistance at the penalty phase by presenting a false picture of Mr. Boozia's life, specifically by failing to discover and tell jury about his brain damage and the devastating consequences of substance abuse and mental illness that have plagued the Bizia family. Focusing first on the false picture of the brain damage, Dr. Reebsheim testified in the penalty phase that Mr. Boozia was not brain damaged. In fact, at post-conviction, after numerous evaluations and a PET scan, post-conviction counsel presented evidence, uncontradicted evidence, that Mr. Boozia has brain damage.
Wait, I thought that there was some dispute with regard to the PET scans. Am I wrong? I thought there was other evidence and experts that came in and read those PET scans and talked about tilting of heads and those kinds of things.
Your Honor,
isn't that in the record?
That is in the record as far as the dispute on the PET scan itself. What was the testimony below was by the defense experts that the PET scan showed brain damage in the exact same area where Mr. Boozia was struck by a lead pipe.
You said it's undisputed, and I'm not sure I'm seeing that undisputed nature. That's why I'm asking. In fact, I thought there was even testimony from maybe someone at Emory that an expert in this kind of thing that said that they'd even looked at and re-examined other cases in which this is a Dr. Wu. Is that who it is?
Dr. Wu was one of the defense experts on the PET scan.
Right, and said that he's consistently misreads them. So again, you may disagree, and there may be other evidence, but isn't that something that's part of what was before the trial court, and we can't just ignore?
Yes, and I want to be clear. My statement is that there was no contradicting evidence that Mr. Boozia has brain damage. There was contradictory evidence presented about the PET scan. Dr. Mayberg testified.
That's what they relied on, didn't they? They relied on...
Only in part. In part. The main reliance was the neuropsychological testing completed by Dr. Sesta, which was uncontradicted. The PET scan, Dr. Wu read the scan as abnormal. Drs. Cotton and Mayberg for the state viewed the scan as normal. Okay. However, they both testified that they could not rule out brain damage, especially Dr. Mayberg, who had never examined Mr. Boozia.
Well, let's go over, though, first of all, there was an evidentiary hearing.
Correct.
And what did the trial court find about this claim that the trial counsel was ineffective in using an expert that didn't find brain damage?
The post-conviction court, with respect to the brain damage, misstated the law and misapplied the prejudice and the performance prong.
But what facts did the trial court find?
The trial court's sentence on the brain damage, statement on the brain damage was, the question is not whether or not Mr. Boozia has brain damage. The question is whether trial counsel's actions were reasonable. The trial court never made a finding whether or not Mr. Boozia, in fact, suffers from brain damage.
And as far as actions of trial counsel, they obtained a mental health expert. Was there indications that there was brain damage and there should have been further tests done? In other words, we can't just have this sort of second guessing, as you are certainly familiar with. But I find these cases where defense have obtained an expert and done a reasonable job with that expert, that just because you now find an expert that says something else isn't equivalent to deficient performance.
Absolutely, Your Honor. And the issue here is trial counsel did have information before him that should have led him to investigate further. First off, Dr. Reebsheim is not qualified to assess brain damage, and prevailing norms and objective standards and this court's case law and the United States Supreme Court case law indicate that a psychologist, a 30-minute screening by a psychologist, is not sufficient to rule out brain damage. In this case, Trial counsel had an abnormal MRI. They had a client with a history of a head injury, a skull fracture. His face was fractured, shearing into the brain, which is the exact location where the brain damage was discovered by both the neuropsychological testing and the PET scan. Trial counsel also had a report from Dr. Bernstein, who they hired after Dr. Riebsheim in this case, who said further neurological testing seemed critical to rule out a neurological disorder. Trial counsel obtained an MRI that showed an abnormality associated with seizures. Trial counsel went as far in this case to seek and approve a PET scan. They contacted Dr. Hall, who trial counsel believed was a neurologist, who was in fact a psychiatrist, who recommended that scan. They got the approval for the PET scan. There's no strategic decision for them to just stop.
Right,
and in this
go,
case, they stopped.
So let me, you've given me at least answers as to how you would, they're having been unreasonable. The experts that you presented, you were saying brain damage, and brain damage can mean so many different things. What exactly did your experts say that were uncontroverted about the state of any organic problems that Mr. Boozia suffered from?
Dr. Sesta testified that Mr. Boozia has left temporal lobe damage, and the temporal lobe obviously regulates emotion and impulsivity.
What about his impairment? What kind of impairment did he have?
That it was overall a mild impairment.
Mild cognitive impairment.
That's correct.
Right. So as to whether, are you alleging that this would go to establish statutory mitigation?
That's correct, Your Honor. Both Dr. Sesta and the other experts that testified at post-conviction testified that Mr. Boozia met the statutory mental health mitigators.
In what way, though? Because if you have a mild cognitive impairment, how is that really explaining what appeared to be planned and very violent acts?
Dr. Sesta explained that Mr. Boozia met the statutory mental mitigator inability to perform his conduct, that while the brain damage was overall mild, it was still clinically significant and still very much affecting Mr. Boozia. And in this case, coupled with his crack addiction.
How did it affect him in his life? How old was he at the time?
He was, I believe, 39 years old.
And he had the incident of the where he was struck in the face with the pipe. How old was he then?
That was in 1994, 6 years before the crime.
And what was the testimony about how he functioned between, this is certainly as a lawyer, these are the kinds of things you think about, from the time he had this incident where he was struck in the face with the pipe until the murder, as to how did his behavior change? Did he, what was?
Yes. Post-conviction counsel presented and uncovered evidence that trial counsel failed to uncover about after the head injury, the decline into addiction really succumbed Mr. Boozia. He was at this point then having menial jobs to support his drug habit. He became addicted to crack cocaine.
Taking drugs and having brain damage. So the argument is that after he had this incident, he became addicted to prescription drugs?
No, Mr. Boozia has a genetic predisposition to substance abuse, alcoholism, and drug use. It goes back generations and generations. That evidence was not presented at trial and was presented in post-conviction. In addition, Mr. Boozia used cocaine in the early 90s. After the head injury, the testimony was that his addiction, because of the brain damage, affects his ability and makes him more susceptible to the addiction that he's already genetically predisposed to. So the testimony by both Dr. Morton, Dr. Cunningham, and Dr. Sesta was that the brain damage and the drug addiction were interacting with one another, which is much like this court's finding in Orme, where trial counsel in Orme presented evidence only of Mr. Orme's drug addiction.
But in Orme, the counsel didn't tell the experts about the prior diagnosis. To me, again, you have a situation of whether a counsel, and you're entitled to a reasonable investigation, a reasonable counsel, whether you're entitled to what the best lawyer in the world would do or what is reasonable under the circumstances. So in Orme, the lawyer didn't tell the expert about it. Here, Dr. Brisbane knew about the 1994 incident. So I don't see that as being an Army situation.
And in this case, the argument is that Dr. Reevesham is not qualified to diagnose brain damage, and that prevailing norms and dictate that counsel should have known that getting a psychologist to do less than a 30-minute screening is not sufficient to rule out brain damage. In a death penalty case, this is a situation, too, where we have an 8-4 vote. This is a very close vote.
Let's go back to the nature of the brain damage here, and the testimony at the evidentiary hearing that there was a mild cognitive impairment. Is that correct?
That's correct.
What's a cognitive impairment?
It's basically that it affects your brain, it affects your ability to think, to function, to plan.
What does the record show about the defendant's IQ?
His IQ in this case is overall average. The interesting thing about his IQ is he has a verbal and a performance split. I believe it's 19 points, which is statistically significant. And when there's a split between the verbal IQ and
the verbal actually is above average, isn't it?
That's correct.
Significantly above average.
His verbal IQ is above average. And I was referring, and I didn't mean to be misleading, his aggregate IQ is in the average range. But what's significant in this case is the statistically significant split that Dr. Sesta testified is a clear indicator that somebody has brain damage.
What were the factors that you believe demonstrate that counsel should have had someone else evaluate to do the testing, a neuropsychologist to do the testing for the brain damage? Was there something that you're pointing to? These are the set of facts. Your fellow worked for Universal or something at one point?
At some point, the testimony in conducting this biopsychosocial history was that he was able to sort of hold it together for longer in his family than anyone else. What were the
flashes? What are the red flags that you think that? So you say this lawyer knew this and should have done X.
They had the 1994 head injury where he had a facial fracture. He was struck in the head with a lead pipe. They had the knowledge that he had been using and abusing crack cocaine for many, many years prior to the murder. The knowledge that Dr. Bernstein had done a screening that indicated there were some deficits that needed further testing. Okay, so that would be the key, really, because the other things, just because I think you must agree that simply because someone has an incident of facial fracture, that automatically says you have ineffective assistance if you don't do brain. So the last one's what really is the key then, right? Well, I think, Your Honor, they're all important to look at. And when you look at prevailing norms and what capital defense attorneys are taught, they're taught to look for things, red flags, such as head injuries, such as drug abuse, and I mean, I think the reason Dr. Bernstein made that finding that, look, you need to test this guy further is because of those things, because of the head injury, because of the drug use. So I think it's
And that's what he told the defense counsel in this case.
And that's what he told defense counsel. And defense counsel testified that there was absolutely no downside to obtaining a neuropsychological
And so why
evaluation.
didn't do it?
He didn't have an answer. He didn't have a strategic decision. He simply didn't have an answer. And he testified there was no downside to doing so.
In the trial court's ruling, the trial court ruled that because the murder was not impulsive, that a showing of brain damage would not have negated the premeditation necessary for it to be a first-degree premeditated murder. So could you address that statement in the ruling?
Certainly, and I think that we argued both the brain damage was important in the guilt phase and the penalty phase. Certainly, negating the finding of premeditation would go to a guilt phase argument. The test would almost rise, and Dr. Cunningham touched on this in his testimony, that in a guilt phase you're dealing with an insanity versus, a not guilty by reason of insanity, so in that situation, that was the judge's finding with respect to premeditation. Regardless of whether it could have been used to negate premeditation, it's certainly relevant in the penalty phase. And the United States Supreme Court in Porter talked about the importance of, giving the jury reasons to understand the defendant's moral culpability may be less, while his legal culpability in the guilt phase that you're discussing may not, the brain damage may not rise to that level. His moral culpability is less in the penalty phase.
Did the trial judge in this case find any mental mitigation?
No, not statutory. The trial judge in this case found non-statutory mitigators. However, what's interesting and what cannot be squared with the post-conviction court's order is he found it only as it relates to substance abuse. And he said the reason he's not giving the statutory mitigator is because they presented nothing other than substance abuse. And then in post-conviction, he fails to address the fact that the brain damage was presented. He fails to undertake the proper prejudice analysis as stated in
Well, it seems
Williams,
me
to
that
reweigh the evidence.
You still have what in this record seems to be a sort of mild cognitive dysfunction, for lack of a better word. And so how does that all play into the fact that the trial judge says that basically that this wouldn't have made a difference?
I think, Your Honor, he doesn't say that this wouldn't make a difference because he doesn't address it. He doesn't address the brain damage as it relates because he fails to undertake the proper prejudice analysis where he needs to reweigh the evidence presented in post-conviction with the evidence in mitigation. He doesn't do that.
So your prejudice argument is that the mental mitigators would have been found?
That's correct. All the experts at post-conviction testify that they would have been. And I want to remind this Court that this is an 8-4 vote. So it's not like this was a 12-0. I mean, Mr. Boozia needed 2 more jurors to vote for a life sentence. And this was a case where none of the testimony about his addiction was even presented to the jury because it was presented at the Spencer hearing.
And so if you go back for some new penalty phase, and you have, however, the state's experts who basically, say that there was this PET scan does not show this damage that the defense argues, et cetera. So then you get into that kind of situation.
And I want to answer that briefly with 2 questions. I see I'm into my rebuttal. First off, that's the similar type of thing that happened in Porter was just because experts disagree, the courts cannot reduce to irrelevance the other testimony and the effect that it would have had on the jury because it's up to the jury to determine then do they believe the state's expert or the defense expert. This jury never got that chance. The other point that I want to make is that there was no testimony.
If that's the law, then every post-conviction case results in a reversal, but you have to retry it. All you have to do is bring in people who will differ with the expert testimony. So do you have to have a credibility weighing, and a trial judge has to be able to do that. That's the finder of fact in this process, isn't it?
In post-conviction, are you referring to?
Yeah.
Yes, and that's the problem in this case. The trial judge never addressed whether or not Mr. Boozia has brain damage and whether that would have affected the jury.
So that's the problem, not that that there's only one kind of testimony. There is conflicting testimony with regard to brain damage. Am I understand that?
The only testimony is with regard to the PET scan. No one challenged Dr. Sesta's data. There's no requirement for a PET scan. A PET scan is corroborative data of brain
I understand.
damage.
We see those things. I mean,
right. So,
but it makes a difference if there's merely a dispute, because you are making an argument that if there's a dispute, we have to have an evidentiary hearing again and a new trial, penalty phase anyway. That's what I'm understanding you to start saying now.
And perhaps I'm not understanding your concern.
You seem to be saying is that there's a case that says if there's conflicting evidence, you have to send it back for a new penalty phase.
No. What I'm referring to is Porter discusses the error in the trial judges and in the court's finding of prejudice when you just simply reduce to irrelevance because there is conflicting testimony. Because the state in Porter, actually, the defense experts and the state's experts disagree, but much like in Mr. Boozia's case, they couldn't rule out abnormal cognitive deficits. And Dr. Danziger testified for the state he can't rule out brain damage. And neither can Dr. Mayberg and neither can Dr. Cotton. Dr. Mayberg and Cotton focused that the PET scan was normal.
I think the only question, and I see you're in your rebuttal, but to me, the more significant issue is because this is a mild impairment, how does it really undermine confidence in the outcome in light of the aggravators? And we can look at that separately as to, let's assume that you're correct, that there was evidence of mild cognitive impairment. Why would that undermine our confidence in the death penalty? And you've keep on saying there's but that's not look at.
I would urge this court to review Dr. Sesta's testimony wherein he specifically talks about that question that yes, it is mild, but this is something that affects Mr. Boozia's life because even though it's mild, it still affects his thinking, his thought processes, and his actions on the day of the crime, and that coupled with his severe addiction to crack cocaine caused his behavior on this day. And I see that I'm well into my rebuttal, so I'm going to save some time for further questions.
May it please the court, my name is Barbara Davis. I represent the state of Florida. responding to Justice Lewis's question. In the trial judge's order, it's page 8 of his order, it's page 2289 of the record. He does discredit Dr. Sesta's testing. He says that the testing, in order to attain a score, Dr. Sesta vacillated between different scoring methods to score the defendant's deficits, apparently in order to obtain a score that barely showed the defendant to have mild brain impairment. Footnote 6, he discredited Dr. Sesta's testing methods. It was impeached. He was cross-examined vigorously. Also, the judge in his order found that the evidence of brain damage was dubious at best and a red herring. The defense presented at the evidentiary hearing several experts who had conducted testing. The state presented 4 experts, Dr. Helen Mayberg, she's the expert from Emory. It was Dr. Eric Cotton, the head of the National PET Scan Center, who said that it was a normal PET scan, and Dr. Wu's PET scans, he had seen 3 of them, and he disagreed with all of them.
But did any of them say he did not have, did they say specifically he did not have brain damage?
They said there could be some mild cognitive impairment. However, that did not affect anything that had to do with the crime because it showed calculated ability to plan, methodology. There were no impulsivity involved in the method of the crime. The judge in his sentencing order, I would point out, found that this is his sentencing order back on the direct appeal record, that it could not be denied that the defendant suffered from mental and emotional symptoms as the result of substance abuse. It was the effect of the criminality to appreciate, where he said other than substance abuse, there was no real evidence that he could not appreciate the criminality, and that he was clearly able to plan, calculate, and there was no evidence whatsoever in the facts.
Can you go over that? The 1994 incident was known to trial counsel and known to Dr. Brisbane, correct?
Yes.
It's described in the trial court's order as a facial injury.
Yes.
Facial injury is pretty different than brain damage. Sent to the emergency room, and I mean, in other words, what was the aftermath of that injury? Was he hospitalized? Was he, was there a marked difference right after it in terms of what should have been discovered as to the significance of that injury?
And if you look at Dr. Helen Mayberg's testimony, she talks about the fracture. It was a fracture to the eye socket. It was not even an orbital fracture. They did a CT scan, did not see anything. He was released in 2 to 2.5 hours from the hospital. The alleged brain damage that Dr. Wu found was in the temporal lobe, which is back in here, and both Dr. Mayberg, primarily Dr. Mayberg.
I thought it's who testified to something being in the frontal lobe?
The frontal lobe controls impulsivity.
That's what I'm asking. So you're saying Wu found evidence of brain damage in the temporal, which is you're pointing to the back of the head.
Well, it's around in area in here inside. And Dr. Mayberg said that not only was there no brain damage pursuant to the PET scan, but even if there had been some injury to the eye socket, it would not translate to the temporal lobe. Additionally, if they were trying to show impulsivity in actions or brain impairment, that's frontal lobe.
Correct. So nobody did they testify that they had frontal lobe damage?
No, it was temporal lobe. But
so what about? I thought that the argument first of all was very, very good professional argument today in this case. But the idea that there was a red flag for trial counsel in the form of the other doctor's report. Could you address that?
Dr. Bernstein had done an exam of Mr. Boozia. He said, I suspect there could be something. You need to do some neurological testing. They did 2 MRIs. The MRI showed a venous angioma, which is a small tangle of veins, which could cause seizures. He had no history of seizures. They defense counsel had obtained the funding to do a PET scan and the permission, but Dr. Reebsane said there's really nothing there. A venous, and all the doctors agreed, a venous angioma is nothing significant. It's not
They
brain
also
damage.
criticized counsel for relying on Dr. Risbin, who's a psychologist, to be attempting to diagnose brain damage. What is your response to that?
Well, as the record shows, Dr. Reebsane has asked for PET scans when he sees indicia of brain damage. And remember, Dr. Danziger also came in for the state. He's a psychiatrist. He said there's no indicia of brain damage. So, and then we go to the evidentiary hearing, and we prove he doesn't have brain damage. There may be some mild cognitive impairment, probably because of the substance abuse. As far as the 94 injury, he worked as he was in junior management or management at Universal until 1996. His criminal behavior, his minor criminal behavior, was showing up back in the 90s. Bill Bennett testified. He was a prosecutor. He showed up in court, and there was Mr. Boozia on a solicitation of prostitution. That was 90 to 91. He had a DUI in 90 to 91. So at 94, as the judge found, there was no indication that he started committing violent acts or committing crimes.
But what about his use of drugs at that time? As I understand their argument is that, you know, he has some predisposition to the use of drugs and alcohol, and that this injury in 1994 manifested itself in that he started really abusing drugs. I think that's what part of their argument is.
Well, and that may be part of their argument, but the record shows that at the penalty phase and at the evidentiary hearing, it was established he started using powder cocaine with his sister and brother-in-law in 1996. He started using crack in 1997. And
So this was sometime after the 94 injury?
Yes.
Okay.
Yes. And he had used cocaine periodically. He was introduced to it when he was at FSU in the 80s. And then Bill Bennett testified about they were at a wedding subsequent to that, and he was using powder cocaine. So, and as the judge found in his sentencing order, when he sentenced him, there is no question he is a substance abuser. He gave substantial weight to the extreme emotional and substantially impaired, although it wasn't extreme and substantial, it was as non-statutory mitigation. And as the trial judge found at the evidentiary hearing, everything that was presented at the evidentiary hearing was presented at the penalty phase. Now, as he said, there were additional anecdotes, there was more detail, but that's not the standard. We had a complete picture of John Boozia's life from the time he was born, his alcoholic father, the entire this is the penalty phase. His entire family was alcoholic. They abused drugs together. Everything was laid out at the penalty phase. The only additional thing we have at the evidentiary hearing is more detail. And as far as ineffective assistance of counsel, if you look at the amount of investigation he did in winnowing through these witnesses to choose the best witnesses, and 3 of the witnesses, well, 4 of them that testified at the evidentiary hearing were exclusively excluded because either they had inconsistent information, the brother Jack had done a deposition and said all these things that would be inconsistent with the theory of defense, the strategy, the McIntoshes did not want to testify, and this was explored at the evidentiary hearing. They recalled 7 witnesses at the evidentiary hearing that had testified at the penalty phase, who had testified as to his childhood and the escalating drug abuse.
Well, I think their argument on that point is that these people were not properly prepared to give the information that they had at the time of the penalty phase.
And if you look at the defense attorney, Tim Caudle, he was recalled by the state at the end after we were able to obtain more information, went through his investigation, and he basically contradicted. Bill Bennett said he was a capital defense attorney, Now, remember, he had been scheduled to testify in the morning. It's in the record that he could not come until the morning testimony. And then he comes in the evidentiary hearing and said, oh, I wanted to meet with them all day and then testify in the afternoon. They're in the middle of a penalty phase. This guy is a seasoned defense attorney, and he came in and wanted them to tell him how to testify. Well, you know, they had 15 witnesses. They had talked to these people, and Mr. Caudle said, I talked to Mr. Bennett ahead of time 3 to 4 times, and then Mr. Bennett comes in and says, oh, well, I wasn't prepared to testify. But he told us the same thing at the evidentiary hearing, basically about the cocaine use. At the penalty phase, he told us about an incident where there had been a bar fight, and Mr. Boozia broke it up. So, you know, as the trial judge found, the defense theory was, here is a salvageable man. He is a good person. He breaks up bar fights. He helped the jail after he was incarcerated. And he slid down because of crack cocaine. And that was his theory. Now, that, as Judge Lester found, bad is good isn't always a real good thing. Now we know, okay, he had fights all his life. He was stalking girlfriends, the Hellers, his aunt and uncle. He left under suspicious circumstances in Cape Cod. All of this before 1994. So 1994 is not some kind of watershed moment in his life.
But it seems here that really the opposition is saying that a brain damage, testimony of the brain damage, the cognitive impairment, although mild, places even the abuse in a different light. The average layperson looks at drug abuse, whether correctly or incorrectly, as something that you've voluntarily done, yet if there is some kind of organic brain issue that's causing that to happen, it somehow seems, the argument seems to flow, that's an explanation.
And that's exactly what Judge Lester addressed. First of all, the brain damage is a red herring. Secondly, we knew that he was a substance abuser. Thirdly, he discredited all that, if there's he discredited anything that even if there was some mild impairment, you had to really stretch to get there. And most importantly, the facts of the crime show that this didn't have any effect on him. So how would that be mitigating? When he goes in and he assaults 2 senior citizens with an axe.
I guess, but going back to sort of the crux of what they made their argument on, the jury, it's horrible murders, the jury votes 8-4 for death. The idea is that you sort of say they've already presented all this evidence that crack cocaine caused him to slide. And I thought what Justice Lewis's question is that juries, if there's also, well, it's that, but has this genetic predisposition in his family, that is something that it's not, you know, although there's some voluntary nature to it, it's organic or genetic, and then you add brain damage and there is impairment, even if it's mild. Doesn't that change the picture for the jury seeing him in a more sympathetic light?
We're assuming that the penalty phase is a one-way street, and they just present their evidence and it goes unchallenged. If you look at what was presented at the evidentiary hearing, and let me back off, everybody doesn't agree that he has a mild cognitive impairment. It was Dr. Sesta said that, and Dr. Reeves-Saman Danziger said if there was anything, it's very mild. So let's look at the state's rebuttal to what they present. Dr. Sesta is manipulating his figures. Dr. Wu isn't doing a proper PET scan, and this has nothing to do with the facts of the crime. So you present that to a jury, if we're going to speculate on how this would affect the jury, this thing of maybe he had a mild cognitive impairment, but to get there, we're having to manipulate data and read PET scans in an odd way. So what does that do to the jury? Well, it makes you distrust all of the defense.
But that couldn't be a strategic reason because they didn't uncover it. So you're going to prejudice here. Is
There's
that correct?
nothing to uncover. It doesn't exist.
Well, I thought the argument was when you see this and then you have the red flag, you would pursue it further in terms of getting PET scans. If, let's assume that should have been pursued further and they ended up where they were at the evidentiary hearing, your arguments to me, and properly, go to the question of prejudice. And I think you make a strong point. Can you distinguish then Porter from the U.S. Supreme Court, which was this court's case or opinion that was reversed? How is Porter distinguishable?
Well, Porter, they said that the trial judge did not make a proper prejudice analysis. They didn't change the prejudice analysis.
So what did they say about that you can't just discount another expert in terms of looking at prejudice?
No, basically, they said the judge did not consider all the evidence that could have been presented. So in the evidentiary hearing, they came in and he was a Korean War hero, and he had all these effects after the war, and the judge, in his prejudice analysis, did not consider the cumulative effect of all that information. So that's what Porter had a bunch of things that would be mitigating. In this case, we don't. We don't have anything that would be mitigating. And as far as, I'm not conceding deficiency at all, because trial counsel had 3 experts, Dr. Hall, Dr. Bernstein, and Dr. Riebsame. And he pursued 2 MRIs and then did not pursue the PET scan because Dr. Riebsame said, really, the PET scan is not going to get you anything. He was right. It didn't get us anything.
Did he have neuropsychological testing done? The original defense lawyer?
Now, there's a whole issue in here about forensic psychologists and the testing they do, and neuropsychologists, the testing they do. Dr. Riebsame's testing is the one that showed this disparity between verbal and performance, which is very interesting because Mr. Boozia was a carpenter and a handyman and a landscaper, and yet his performance was way down. No signs of...
It wasn't... The performance was not subnormal. It's just
no,
that,
it wasn't.
The anomaly here comes from the discrepancy between verbal and performance.
Yes.
And that shows that's very unusual to have that sort of discrepancy. It's not that his performance was low.
No. No,
so isn't a discrepancy, it's in between performance and verbal that is unusual? Isn't that, because I asked you about neuropsychological testing, isn't that one of the ways that in neuropsychological testing they decide whether there is brain damage based on things like a significant gap between verbal and performance IQ?
And that can lead you to do further testing.
So what I'm asking you, was that done at the initial, by the initial experts in before the penalty phase?
And I don't know. I quite honestly, there's all these different tests that they do. Dr. Riebsame spent 15 to 16 hours.
You're an experienced lawyer. Those are the issue of neuropsychological testing, IQ testing. You tell me you don't know the differences between those?
I know there's psychological tests, and if they're labeled neuropsychological tests, I'm not sure what's labeled neuropsychological.
I'm asking you whether so they were done, and somebody said that should it be pursued further? That's the question I have.
No. Dr. Riebsame, after he did testing, he said, I don't think there's evidence of brain damage. At the evidentiary hearing, he said, I would stand by that. Dr. Danziger evaluated him for the state, said there is really no evidence of brain damage that he can see as a psychiatrist, and now we know there is no evidence of brain damage.
What was the point of the MRI then? Weren't there 2 MRIs done after they got these reports?
Yes.
And so what was the point of those?
Dr. Bernstein said, I would like to have him screened because he's showing signs that could be objective, that could be physiological. And that's when they did the MRI, the 2 MRIs, and they showed
and what kind of...
And that was supposed to show what? The MRIs.
The MRI would show brain lesion, brain damage, would show gross brain damage. If there were any, same thing as a CAT scan. When he went into the hospital, they did a CAT scan to see if there was any abnormalities, injuries to the brain. So the two MRIs were, it's like a screening thing. Now the PET scan, remember Dr. Mayberg said the PET scan is not really to be used to diagnose psychological disorders. It is for very physiological disorders such as epilepsy, dementia, etc. So, I mean, if, you know, maybe there's a mild impairment, but how would that mitigate this crime when you look at the facts of this crime? And that's what the judge found.
We thank you. Your time is up.
Oh, way over. Sorry.
Well, I want to be very clear that the claim is not trial counsel was ineffective for failure to get a PET scan. Failure to do neuropsychological testing to detect brain damage is the claim. There was no neuropsychological testing done. Dr.
Was
Reed
that some done? It was some done for the evidentiary hearing.
It was all done in post-conviction. Dr. Reed seems.
And what's different about a neuropsychological exam versus what was actually done?
All that a psychologist is authorized under their code of ethics to do is a screening for brain damage.
No, I said, what is the difference?
The testing is a lot more specific. The testing that Dr. Sesta conducted was hours and hours of hundreds of different tests. Dr. Reebseim's screening was 30 minutes. It was 2 tests. He made this finding based on less than tests that took 90 seconds.
But did Dr. Risbane, who is a psychologist, who first saw there was this discrepancy, did he recommend mild further neuropsychological testing?
Dr. Reebseim never knew about the discrepancy. That's not accurate, and I want that to be clear. It was Dr. Sesta's IQ testing that discovered the discrepancy. Dr. Reebseim didn't know about it. So the trial counsel did not know about it because it was Dr. Bernstein who had suggested the further testing. And just to point out, this further testing, the MRI, it was abnormal. I understand that Mr. Boozia didn't have the seizures, and so, but it's not like you get this person where they say, let's do some more testing, and then the next test you do is abnormal.
But that's not connected, as I understand it, to anything that's involved in this case.
The MRI is not connected,
right,
but the
that's
fact
what I'm
that
saying.
Mr. Boozia...
So your better argument is this testing. What kind of doctor was the individual who had recommended additional testing?
Dr. Bernstein was a psychologist. And
and
that's because it's not proper for a psychologist.
Oh, I understand.
Yes.
And the other was a psychiatrist, so you didn't have anybody in the defense team that was authorized to do or that does competent testing.
No,
it's a neuropsychologist that does that testing.
That's not correct. Dr. Sesta is a neuropsychologist.
No, I'm talking about the defense.
Oh, I'm sorry, Your Honor.
Yeah.
Yes.
So that's your argument.
That's my argument.
Yeah.
That's correct. And just, I know I'm out of time. I just briefly, in this case, the jury heard a false picture of Mr. Boozia. They heard that he was not brain damaged and that he had a normal, stable, middle-class life. He didn't. This family was deeply devastated by substance abuse. His own substance abuse, coupled with his brain damage, led to this crime. And I ask that the penalty phase be reversed.
We thank both sides for your argument. That concludes today's docket.
Please rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.